If a married couple uses marital assets to buy back service credit for one of the spouse's pension, when they ultimately divorce, is that considered a marital asset? To find out, you have to read Szypula versus Szypula, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Szypula versus Szypula. The citation for this case is 2024 New York Slip Opinion 05177, published by the New York Court of Appeals on October 22nd of 2024. The issue in this case is whether part of a pension that relates to pre-marriage service is that separate or marital property when it's obtained through a buyback using marital joint assets. To understand and appreciate the context of this case, the helpful background to know is that under domestic relations law, which is the New York section of law that addresses dissolution of marriage, divorce, annulments, all those termination of the marriage agreement. Under domestic relations law 236, it defines and describes different categories or classes of property: marital property and separate property. Marital property includes all property acquired by either or both spouses during the marriage, with the exclusion of what separate property is. And separate property is property acquired before the marriage and property acquired in exchange for or the increase in value of separate property, except to the extent that such appreciation is due in part to the contributions or efforts of the other spouse. So separate property can become marital property if it's commingled with marital property or if it's enhanced by value based upon the contributions of the other spouse. There's a couple of general rules that govern dissolution of a marriage and determining equitable distribution of assets. A couple of those general rules are marital property is to be construed broadly and separate property is to be construed narrowly. So the presumption is, in general, that things are marital property. And the presumption actually is that all property, unless clearly separate, is deemed to be marital property. And to overcome that presumption, the party seeking to have the property declared separate property, the property that claims they have title of the property, has the burden. They have the burden to rebut that presumption that all assets are marital property. And the last thing you have to know is that there's a Court of Appeals case, a landmark Court of Appeals case called Majewskis versus Majewskis that says that pension rights are marital property when they were acquired between the date of the marriage and the commencement of the divorce. So if you start getting a pension while you're married and then you get divorced, that is a marital asset. But what's unresolved by Majewskis versus Majewskis and addressed by this case is what about pre-marriage rights that are bought back during the marriage? Okay, so what are the facts in this case? The facts are that John Szypula joined the United States military, the Navy, when he was 22 years old, and he worked there for 9 years before he married Meredith Szypula, she became Meredith Szypula. He continued to work in the Navy for 2 more years while they were married, and then he left. You need 20 years of military service to get a retirement in the military. He didn't have it. So when he left after 11 years, he was not entitled to any pension benefits. That's important. John then worked in the private sector for 14 years, and after that, he joined the public sector again. He joined the Foreign Service, which is a part of the State Department. The employer is the United States government, just like it was when he worked for the Navy. But one of the abilities that he had while he was in the Foreign Service was they gave him the option to buy back. A veteran can buy back time when they were in the service, when they were in the military service. They can buy it back. And so John and Meredith took advantage of that and used marital resources, $9,158, to buy back the 11 years of military service that he hadn't yet bought when he was in the military, the 9 before he was married and the 2 after he was married. As a result, John's foreign service pension will vest sooner, will be higher. And in 2019, the Szypulas filed for divorce. And at that point, they resolved a lot of the issues, but one of the issues that was unresolved was the distribution of assets, the equitable distribution of the property, what's marital and what's separate. One of these disputed issues was that portion of the foreign service pension that was attributable to the 9 years before they were married. Because Majewskis versus Majewskis says that was while they were married, so obviously that's marital. But what about the pre-marriage service that was bought back with the marital assets? Supreme Court held that part of the pension, the 9 years in the front end, was marital property because it was bought with marital funds. It goes to the appellate division, and the appellate division reverses, saying it was separate property. Why? Because John was in the Navy by himself. It was a product of John's sole labors and not due in any way to merit his contributions. But they did hold that the marital funds that were used to buy it were marital funds, and that sure there should be a credit for that. It goes to the Court of Appeals, and here the Court of Appeals holds. This is an important landmark case in some ways. The Court of Appeals in this case holds that when spouses use marital funds to buy back and convert the 11 years of Navy service credits into pension, that adds additional value to the pension. Those pension rights are therefore the product of both pre-marriage services by John only and the combined marriage contribution of the marital assets. And like we heard before, the general rule is if you commingle separate property and marital property, it becomes marital property. So here, because there was pre-marriage service that would have been just John's, but marital assets were used to buy it back, that has now become marital assets. This is not resolve the equitable distribution question totally. Still has to go back to court for them to decide the percentages and all that. But that is the holding of this case, that when you commingle it, even though it's pre-marriage service, that becomes marital assets, marital property. And that's the case of Szypula versus Szypula. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.